Please be seated. We are hearing a case Muncie ACV 17-0470, Premier versus CORK et al. Each side will have 20 minutes to present their argument, and appellant, you may reserve any portion of the time for rebuttal, but you're responsible for keeping track of your own time with a clock at the podium for that purpose. We are recording the argument, so in a few days you can re-watch the argument on YouTube. Because we're recording it, please identify your client and yourself when you begin your argument so that we can keep everything straight. We've read the briefs and the record. We've conferenced the case, so we're familiar with the case and the argument. So when you begin your argument, just start writing on what you want us to know. Counsel, you may begin.
Good morning, Your Honors. My name is Jim Armstrong from the firm of Sachs Tierney. Joining me at counsel's table is Andrew Turk, and we represent the appellants in this case, John and Susan CORK. Mr. CORK is also present in the courtroom. I would like to preserve some time for rebuttal, and I look forward to your questions. This case concerns the untimely renewal of a deficiency judgment against the CORKs by the appellee Premier Capital. Both sides agree that the questions of statutory construction at issue are subject to de novo review. Under ARS Section 12-1551B, every Superior Court judgment automatically expires and becomes unenforceable 5 years from the date of its entry, unless the judgment is renewed by affidavit or by bringing an action on the judgment within that time period. In this case, Premier attempted to renew its judgment, its deficiency judgment against the CORKs by affidavit. And under the governing statute, Section 1612B, that affidavit had to be filed, quote, within 90 days preceding the expiration of 5 years from the date of such judgment. There is also
90 days isn't really at issue here, though, right? I mean, the 90 days is just the window.
Correct.
So we don't care about the 90-day period.
Well,
we're concerned with the
other than
expiration of the 5-year period.
Correct, other than the fact that it does establish that window within which the affidavit must be filed.
And then, regardless of that date, though, the affidavit was filed within the 90 days.
Well, yes, well, not really, because it was not within 90 days preceding the 5th year anniversary of the judgment. So it missed that window. It was filed after the expiration of 5 years from the entry of judgment, so it fell outside the window.
But again, just because we're going to be parsing a statute here today, the 90-day period is not relevant to our analysis. The only question is whether it was recorded after the expiration of 5 years from the date of the judgment, right?
That is why we're all here today. Correct.
Because if we were to disagree with you on when the 5 years expired, the affidavit would have been within the 90 days, correct?
If you disagree with me,
yes.
Yes.
Yeah. All right.
Okay, I'll grant you that, Your Honor. What's also not in dispute, however, is that the renewal statutes are required to be strictly construed.
What does that mean? What does the term strictly construed mean?
Well, Your Honor, in fact, in the Galloway case, talked about that.
Are you by saying strictly construed just meaning literally construed, or when people use that term, sometimes it can have different meanings to different people?
Well, the word you used, Your Honor, in Galloway was rigid construction, rigid application of the time period, and that's what we're talking about here. Strictly construed means constructive compliance is not enough. Although even in this case, even under the renewal statutes, courts have sometimes been lenient on certain requirements for the affidavit. For example, renewal affidavits have been upheld where the amount remaining due under the judgment was misstated in the affidavit. So courts have overlooked that kind of mistake. But again, in Galloway and subsequent cases, it's very clear that the time frame is rigidly construed, and there can be no variation no matter how close the filing might fall outside the window.
Okay, that's fair.
The facts of this judgment renewal are also not in dispute. The deficiency judgment was entered on January 10, 2011, and that judgment was later assigned Premier by the original judgment creditor. And under Section 1216.12b, Premier was therefore required to file its affidavit within the 90-day period preceding January 10, 2016. Instead, Premier waited until January 11 to attempt to file an affidavit that was rejected by the Superior Court clerk because its caption did not match the names of the parties.
Well, counsel, the 5-year period, as I understand it, ended January 10th. Correct?
Yes.
So under Rule 6, when you then bump that to the next business day, which would be Monday.
That's what Commissioner Benny held, and we believe that's incorrect.
And under Rule 6, you count forward, so you bump it over to the next day, right? Is that what 6A3?
Yes, but that only applies, however, under the case law, under the Board of Supervisors case, under the Helm case, both Supreme Court decisions, the other cases we've cited. The rolling forward application of Rule 6A only applies to statutory time periods that require counting forward.
Well, and it's 5 years forward, correct?
There is a difference here, however, and it's the statute that I just mentioned. A statute that cannot be ignored in this equation. And that's Section 12-1551B, which states, an execution or other process shall not be issued on a judgment after the expiration of 5 years from the date of its entry unless the judgment is renewed by affidavit or process or an action is brought on it within 5 years from the date of entry of the judgment or its renewal. That statute has been interpreted by this court in the Cry v. Edwards case as stating that under that statute, under 1551B, it is the judgment creditor who must act to prevent expiration, not the debtor who must act to achieve it. If the creditor fails to renew the judgment, it expires. The judgment debtor need do nothing. So what we have here is a statute that automatically extinguishes the judgment on the 5th anniversary date.
So if it falls on a weekend, that's your bad luck.
I'm sorry, excuse me?
If it falls on a weekend, then it's your bad luck because you can't do it.
Well, actually, under the days of electronic filing, you could actually do it. And you have, again, the 90-day window preceding the 5-year anniversary date to affect your filing. So I think the statute is very fair, and I think that, the Supreme Court pointed this out in the Friedman case, that yes, there is some risk under the statute that a legitimate liability, will be extinguished, but that's true with all statutes of limitations. And to mitigate that possibility, the legislature created this very simple procedure, giving people a significant amount of time in that 90-day window to file an affidavit to preserve their judgment. If they don't do it, the judgment expires as a matter of law, and I think what the court was referring to is, again, 1551B.
Well, and there's no question that what you said about 1551B is right. It's very difficult to dispute anything that you said. But what the real question for our purposes today is whether 1612 or 1551B ever require you to look backwards. It seems to me that for purposes of our analysis today, the question is, did something happen within 5 years from a date in the past? So take that date in the past, you count 5 years forward, that's your date. That may sound oversimplified, but if there's something wrong with what I just said, please tell me.
Well, I think you have to reconcile 1551 and 1612.
Are they in conflict?
I think they are. I think again, under the Cry versus Edwards decision, I think it imposes an absolute terminal date on the life of a judgment, and to allow Rule 6A in conjunction with Rule 1612 to somehow revive a judgment that by the terms of this statute is automatically eliminated, is extinguished on the 5th anniversary. I don't think you can harmonize the statutes that way. The other point is the language of Rule 6A. I'm sorry, the language of this statute, 1612, talks about preceding. What that does is that forces you to count backwards from the date of the 5th year anniversary of the judgment.
Well, if we had a problem where somebody filed a renewal affidavit 100 days before the end of the period, sure, we'd be looking backwards. But the question here has never been that it was filed too early, right?
No, it's not. That's not been the question. But what I think,
I'm sorry, but I'm lost now with this purported conflict between 1551 and 1612. 1551 says the judgment expires 5 years after. 1612 says you can renew it. How is that a conflict?
I think it's a conflict because it says you can renew it, but the way you have to harmonize it is 1551 automatically extinguishes the judgment on the 5th anniversary date. So
unless renewed.
Unless renewed,
right,
prior to that date, within the 90 days preceding that date.
Sure.
Under Rule 6A, you can use the counting backwards and add days in front of that window. If, for example, the 90th day fell on a Sunday or a holiday, you continue counting backwards to the preceding Friday. So you can actually file it earlier. But because of the way that the statute is structured, where it is backwards counting, under the Board of Supervisors case, same thing. I'm not sure if it was a plaintiff or defendant, tried to use Rule 6A to roll forward to the next day, and the Supreme Court rejected it, citing the fact that that statute, like 1612, like the renewal statutes, was strictly construed. It was an election statute, strictly construed, and saying that if we allowed this, then under the strict language of the statute, this would not be filed within, no later than 30 days before the election. So
I don't mean to be pedantic, but I think there's a slight difference between strict construction and strict compliance, which is really what the election law requires. But let me switch gears for a moment. What's your position, if any, with regard to how we should treat the caption error?
We are assuming arguendo that this was constructively filed on January 11th. We're not.
You're not challenging.
No, we're not.
You're not saying that when the statute requires the names of the parties to be listed in the affidavit, that strict compliance with that section is required?
No, we're not. I mean, we did in the trial court. On appeal, we felt this is the better issue, and we wanted to focus on this issue because no matter,
I just wanted to make sure.
Okay.
So is the argument really that the statute provides the substantive law that the judgment expires on X date unless it's renewed, and that's in Rule 6 as far as extending things or computing the time apply?
I'm sorry, is it a what?
Are you saying that the statute says substantive law, and that since Rule 6 deals with procedure, that the procedural rule can't trump the substantive law? Is that what you're saying?
Well, hadn't really thought about that until right now, but I think that's true. I think because the substantive effect of 1551B is to, again, automatically terminate the judgment, the enforceability of the judgment.
Would you say that there's a fair analogy between this situation and that of a statute of limitations? Such that if you have a 2-year statute that expires on a Sunday, can you file your action on Monday, or do you have to file it the previous Friday?
No, because that is a statute that counts forward. I mean that a limitations period naturally counts forward from the accrual date.
But they're written using the same language. The limitations period counts forward from the accrual date. The 5-year counts forward from the judgment date. If you agree that there's a fair analogy between the two, why wouldn't Rule 6 apply?
Strict construction, rigid construction of the time period, automatic extinguishment of the judgment with a limitations issue. I don't believe limitation statutes are construed strictly.
I'm going to have to keep stopping you. There's no ambiguity, so there's nothing to construe strictly or otherwise, as far as I can see. It's the compliance that has to be strict or not.
Right.
And I think with statutes of limitation, we get quite persnickety about the difference between January 1 and January 2. Right? We take that time frame literally. So if Rule 6 can apply to a statute of limitations compliance, why could it not apply here?
Well, this statute has never been put under this kind of scrutiny on review.
But do you see a difference between this statute and a statute of limitations?
I do. Two differences. Again, the forward-counting nature of a statute of limitations, the fact that it is not strictly construed, and 1612 being impacted by 1551.
For about the 5th time, if you can point to an ambiguity that requires construction, please let me know. But I'm unaware of any law saying that we don't rigidly apply the time frames under statutes of limitation. As far as I know, we do. So when you say that's a difference between these statutory schemes, I'm not seeing where that difference comes from. Do you have a case that says we treat the deadlines in statute of limitations lightly, or substantial compliance is good enough, anything like that?
No, I don't.
Okay. So we do rigidly apply the time frames in statutes of limitation, right? And those statutes are written in a forward-counting way, saying there's a date of accrual and then we count so many years forward. That seems, in my mind, to mirror the language of this statutory scheme, so I'm still searching for the difference.
I don't think it mirrors this statute because, again, this statute speaks in terms of a period preceding a terminal point. It's as if a judge in a case said, I want your briefs filed on a certain day, May 31, and May 31 happens to be on a Sunday. I don't think Rule 6A in that situation would allow you to go beyond the Sunday to file on a Monday. Because
the judge would have put you in a rather uncomfortable spot, though.
Because that establishes a terminal date beyond which you cannot go forward. And this statute assumes that terminal date and is backward facing.
Well, if this statute said on December 31 of the 5th year following entry of the judgment, that would be a terminal date. I would then know that December 31 means December 31. But what it says is 5 years from the date of entry of the judgment. Right?
Yes.
So we have two time periods, getting back to our initial discussion. We have the 90-day window, which means it is possible to file it too early and therefore make it ineffective. And then we have the 5-year deadline beyond which you cannot file it. Are we tracking so far? Okay.
Right.
So if that's the case, and I'm struggling now to find the difference between the 5-year deadline under this statute and say the 2-year deadline under 12542.
Right.
Is there some linguistic difference that would get us into this construction arena that you've been talking about?
No, not a linguistic difference. And I'm saying I'm down to 1:30 if I could reserve the rest of my time. Thank you.
Thank you, counsel. Counsel?
Good morning, Your Honors. John Lohr with Heimson, Goldstein, Pantilliot, and Lohr on behalf of the appellee, Premier Capital. In summary, there's 4 arguments presented to you today from the appellee's position. First, the appellant cannot change their position from the initial court pleadings. Second, the affidavit renewal deadline does roll over to the next business day under Rule 6. Third, the court must count the deadline in the renewal statute forward, not backward, as appellants would like this court to believe. And then finally, which I didn't hear it on argument, but the new Rule 6 just does not apply. As a way of an introduction, this case is really about a day. Do we add a day or subtract 2 from a judgment renewal deadline when that deadline files on a weekend? Premier's position is that the court must add a day to the renewal of the judgment deadline when the deadline falls on the weekend, which ruling would be consistent with the rules and laws of Arizona.
Would you agree with counsel that the statute's to be rigidly complied with?
I don't see a problem with rigidly construing it, but that's looking at it in a vacuum. You still have to look at the applicability, whether Rule 6 applies or not. And we're dealing with a civil lawsuit. Unlike the cases that they've cited, the election cases, which had nothing to do with an even court proceeding, and didn't even look at Rule 6.
I know that appellants haven't relied on this point, but the affidavit that was filed, even if the Monday was timely, didn't accurately list the names of the parties, which is a requirement of the statute. Why is that more forgivable, apparently, than the...
So again, you have to look at the facts of this case. You can't look at it in a vacuum. The facts of this case are, when the renewal deadline came up, my client wasn't even a party to this case. J.P. Morgan was still the plaintiff, and Mr. Messenger was the attorney of record for J.P. Morgan and Chase. For some reason, they did not file the affidavit of renewal.
When did your client buy the judgment?
Back in 2011, but the problem was we couldn't intervene in the case because of the bankruptcy. Mr. CORK was in bankruptcy for nearly 4 years, and it wasn't until September of 2015 when the bankruptcy court finally held that he can't get a discharge of his debts because of some fraudulent activities that he participated in. So during that time frame, my client could not intervene in the case because the case was stayed. And once the bankruptcy case, once we realized we could move forward, then my client hired our firm and said, "Hey, we need to start enforcing this judgment." So the first step we had to do was intervene in the case. I contacted Mr. Messenger and said, and this is in the record, Mr. Messenger, the best way to do this is you file a notice of substitution of counsel. For me, I represent J.P. Morgan Chase for 30 seconds, and then I file a notice of substitution of parties. Or we do it vice versa. They wouldn't agree to do it, despite the fact that they had sold my client this huge judgment. Instead, they said, we have to file a motion to intervene.
But however unfortunate those circumstances may be, we're talking about actual compliance with this statute.
I understand. So when we filed the motion to intervene, it very clearly said that we were the new plaintiff, that we took over the judgment. So we had presumed that because of what was in the court's order, that we were the plaintiff, that the caption would be automatically changed, that the clerical work that needed to be done to make us the plaintiff would have been done. So when we filed the affidavit of renewal, we thought we were complying with the statute because of what was in the court's order. Unfortunately, you had a clerk of the court who obviously disagreed with this and rejected the filing, which we refiled it under a caption which really shouldn't be in existence on January 13th. And just to make sure that we had everything, fully clarified that we are the plaintiff, we then filed the notice later on, or the motion to change the caption, and that was granted, subsequently, I think in February of 2016. So it's not a question of not following the statute. We relied on Rule 6, just like we would in any other civil proceeding, believing that we had the extra day. We followed the statute because we believed, based upon the trial court's order, that we were, the intervening party, that we were the plaintiff. So we believe we complied with the statute. Again, the court just needs to decide here whether it will honor the additional day of Rule 6 when a renewal of judgment deadline files on a Sunday, like all other filings in a civil case, or not. Finding in the court's favor that 2 days should be subtracted from the 5-year judgment renewal deadline would be inconsistent with the legal rules and legal precedent. Finding in the court's favor would essentially rewrite ARS 1612B to say that if the deadline falls on a weekend, you don't get 5 years, but instead you get 4 years and 363 days. Surely that's not what the legislature intended, but that is their position. Finding the court's favor would also give the courts an enormous and unjustified and inequitable windfall of over $4.5 million. Premier relied on Rule 6 when it renewed its judgment on January 11, 2016, believing it had the right to the extra day. On January 11, 2016, there was no rule, there was no statute, there was no case law that existed that would make Premier believe that it could not rely on the extra day given, and that is consistent with all commercial litigation cases coming before it, that when a deadline falls on a weekend, you get the extra day. But the court should not make such a ruling that would have the retroactive effect when Premier relied on that Rule 6 when it filed its renewal affidavit. Ruling in Premier's favor and sustaining the trial court's ruling that the extra day is allowed when renewing a judgment if the deadline falls on a Sunday would be consistent with the reading of the statute and Rule 6 together, and simply fortify and clarify the rule for future litigants. Ruling in Premier's favor would also be consistent with the position the courts originally took in their response, where they did concede that January 11th would be the proper day. There are a couple facts that I would like to add that were in the record, but I want to make sure that they are clarified. In January 2016, after the affidavit of renewal was submitted, my client started taking collection efforts. There was nearly 14 months of collection efforts that went forward without an objection on the renewal of the affidavit. In fact, in July of 2015, Mr. CORK filed an answer on behalf of Coronado West, his company, where he admitted that the judgment itself was valid, and filed an answer to a writ of garnishment. So it seems pretty disingenuous that they would somehow now change the position 14 months later after collection efforts had proceeded for 14 months uninhibited, and when the affidavit was not objected to at all. A couple things that I did want to point out on the cases that dealt with the extra day. Those do support what we're trying to accomplish here today. In the Upton versus Cochise County case, the appeal deadline was on a Saturday, and it had a similar within 90-day language, and the court gave the party in that case the extra day. In the Salmon versus Morenton case, again, it was that statute of limitation case that fell on a Saturday. The court said that they give the statute's liberal construction when the deadlines fall on a Saturday, and it gave the appellant in that case the extra day. The cases cited by defendants, I do want to emphasize those a little bit. The Board of Supervisors of Maricopa County versus Superior Court, again, that's a 50-year-old election case. It's not even a case dealing with a court deadline. It's an election deadline when ballots should be submitted. Rule 6 was not even contemplated when the court made its analysis in that case. And we also pointed out that was distinguished by Fisher versus City of Apache Junction, which actually dealt with some court deadlines on filing petitions in election cases, and in those cases, the court did give the extra day. The other case that was cited by the appellants was the Equitable General versus Helm. It looked at a change of judge, and that case, again, it did not review the Rule 6, in conjunction with that rule. And again, the language was different because it used a before language rather than a within, like in our case. The other case, Matrisky versus Chase, they cited that again for the proposition that no extra day should be given. But again, in that case, they didn't look at our affidavit of renewal statutes. They also didn't look at Rule 6. It dealt with a notice of forfeiture, and again, that's not even a court proceeding. It's a type of foreclosure dealing with real estate that is done outside of court proceedings. So again,
speaking about outside of court proceedings, was this affidavit ever recorded?
Yes.
The county recorder.
Yeah, I can't tell you the date offhand.
But it was, and I don't dispute that would be a prudent thing to do. I'm not seeing a requirement for that.
It's really up to the judgment creditor to do something like that. If you want to record it and you want to have a lien on somebody's real property, you record it. If you really don't care, then you don't record it. In this case, we're not aware of any real property that Mr. CORK owns. So I'm pretty confident we did record it, but even if we hadn't, it wouldn't have any impact.
I'm just trying to explore the finality of the affidavit, but I think I agree with your reading.
Okay. Well, I believe I've covered everything. This is a pretty simple matter. It's really, do we apply Rule 6 or not? We believe that the liberal interpretation of the rule and the statute would require it. Otherwise, it's going to be an extremely harsh result. Again, there was no existing case law or rule or statute prior to this. And the reality is that the impact, if you ruled in their favor, you're rewriting the statute, which is not what the legislature intended. And you would be rewriting it to 4 years and 363 days instead of 5 years and looking at Rule 6. Your Honor, we ask that you, Your Honors, we ask that you affirm the trial court's decision and award attorney's fees in our favor, unless there's anything else.
Thank you, counsel. Counsel Rebolo.
The statute would not be rewritten to 4 years and 363 days because of the advent of electronic filing. They could have filed Saturday, they could have filed Sunday. There was no physical impediment, like a closed courthouse, to stop them from doing so.
The statute hasn't been rewritten since the advent of electronic filing.
Probably not. I don't know if that for sure, but
And
probably not.
as I'm sure, well, I hope you haven't experienced, but many people have, electronic filing doesn't always work when there's no one there to babysit it. Don't we have to go by the rules and statutes which contemplate that there will be business days on which the court is open?
Yes. And again, that's why this statute generously provides a very large window of 90 days to renew this kind of judgment. That's another reason, that's another area where it distinguishes itself from a statute of limitations.
Well, and how long, speaking of times, how long do you have to change your position? Because, well, the point was made that there was some 14 months where collection efforts were ongoing. What governs that? Is that Rule 60, or is there some other time frame that allows you to challenge?
Let me first note, Your Honor, that argument was not made in the briefs at all. And I think if I heard counsel correctly, he was talking about collection activity in 2015. That was prior to the expiration of the judgment. So yes, there was a period of collection activity prior to the expiration of the judgment that we had no basis to object at that point.
I'm not asking for as frightening a reason as you may be thinking. I'm only trying to decide or to determine when the rules of civil procedure impact the statute. So if there's no challenge to an affidavit of renewal under the statute, just hypothetically, I'm not concerned with the exact dates in this case, would Rule 60 apply?
I do not believe so. Again, we go back to Cry v. Edwards. The judgment debtor need do nothing. That's the quote from the statute.
Let's assume then that an affidavit is filed with the correct case number but the wrong judgment debtor. It's just a wholly deficient affidavit. But nobody notices and nobody objects for 4 years. Could the judgment debtor then, after 4 years, come in and say, this affidavit was deficient?
I don't know the answer to that. I think there might be some basis under Rule 60C to do so, but it is a hypothetical, and
That would have to be Rule 60C6 because you would have to have no time limit.
probably. But that's not what happened here.
No, I understand.
We moved.
I'm looking at just the interplay between statutes and rules, hypothetically.
You know, the other point, although we didn't challenge the constructive filing on the 11th, I mean, the other point is that the only affidavit that appears in the record is something that was filed on January 13th. Which defeats the purpose of the renewal statutes. One of the purposes, and that is to give notice to potential to people who may want to do business and lend money on the property of the judgment debtor. It also facilitates easy record review to determine whether the judgment is still active. So what we have is we have one judgment, that the renewal affidavit that's filed on the 13th. So if Commissioner Benny's ruling is upheld, we have a misleading record, and the purpose of that particular purpose of the statute will be defeated.
There's no judicial action required to effectuate one of these affidavits, right?
No.
So if the affidavit had been filed a week earlier, nobody would even think about this. It would just be in the file, and the judgment would be treated as if it had been renewed.
Yes.
And if it's filed 3 days late, same thing happens unless at that point the judgment debtor challenges the renewal. Correct?
Well, or as we did, in opposition to an attempt to execute on the judgment, raise that as a defense to the execution.
Sure, but it's an oddity, it seems to me, that the statute doesn't require any approval. Just a mere filing is good enough, and then the sufficiency of that filing isn't tested until sometime in the future. That's your understanding?
That's correct, yes.
Thank you, Counsel.
Thank you.
We appreciate your argument. Counsel, we appreciate your arguments today. We'll take this matter under our advisement and issue a decision in due course. We're going to sit at recess, but we're going to remain on the bench while the next case comes forward. Thank you.
Thank you, Your Honor.